Next up we have Kendra Hogan and Rochelle Martin. Rochelle is a contract specialist in the Office of Industrial Partnerships at the University of Wisconsin at Madison. She's been with the Office of Industrial Partnerships since its inception in May of 2012. She's a graduate of University of Wisconsin Law School and worked for a general practice law firm before joining the Office of Industrial Partnerships. Kendra is also a contract specialist at the University of Wisconsin Office of Industrial Partnerships. She received her master's in plant molecular biology and genetics from the University of California at San Diego in 2007, and she received her JD from the University of Wisconsin. Kendra joined the OIP in February of 2013. Kendra and Rochelle will be presenting together on industry-sponsored research and intellectual property in the university setting. Kendra and Rochelle.
Good morning. I'm Rochelle Martin. This is Kendra Hogan. We're going to be talking to you about the industry-university research collaborations, and in particular, we're going to focus on the evolving intellectual property licensing climate. We're going to give you a little bit of background because we do want you to know where we're coming from, and also we're going to talk about some of the types of university-industry relationships and agreements that are used to govern them. Then we're going to be identifying some common areas of disconnect and possible sources of these issues. We're also going to discuss some sources we draw on when we're developing IP and IP licensing policies. And then we're going to talk about some areas that could use improvement in some new models that are being tested. As I said, we're from the UW-Madison Office of Industrial Partnerships, and our office was created in May of 2012. We were focusing on the decline in federal funding, but also the increasing importance of industry relationships, not just as a source of funding, but for the wide variety of other benefits that those relationships offer. Our goal is to ease the negotiation and licensing process for both industry and campus. The contract specialists in our office have experience identifying and navigating the different considerations of the parties during negotiations. We coordinate across campus. There is going to be a designated contract specialist for each school or college, and we also coordinate with our Wisconsin Alumni Research Foundation. WARF is the university's external independent patent management and licensing organization. They do operate as a nonprofit. They're often involved in agreement negotiation because we may enter into terms that will obligate WARF to take action. WARF has played an integral role in patent management reform, and we're going to talk a little more about UW's relationship with WARF later. Our office does handle institutional review, negotiation, and signature of agreements. We also maintain a history of agreements we've previously negotiated so that when we have repeat sponsors sponsoring work on campus, we don't have to start all over from scratch. Our office works with a comprehensive suite of agreements so that there will be one point of contact for the outside company from the start to the finish of the relationship. Because we're from the University of Wisconsin, sometimes when we are speaking, we may make a reference directly to our own university's policies. We're going to make our best efforts to note when we are identifying our specific policies. But in general, we are going to make an effort to talk about universities in general. As I said, we work with a suite of agreements, and those are meant to govern a variety of different relationship types. One of the first ones that often signals the start of a relationship is a confidentiality agreement. This is an agreement to provide proprietary information to another party as long as that recipient agrees to keep it confidential. For the university, we sometimes see these just being one way, where either there's information coming in or going out and the other party does not want to provide any information, but more commonly it's bilateral to encourage the exchange of information. Another type of agreement that we work with is a material transfer agreement. This documents the terms that govern incoming and outgoing materials from campus. A material transfer agreement is going to define the obligations of each party when material is transferred from one to the other. And they're frequently going to include limitations on the ability to use that material either on campus or in the organization, but also the ability to further disseminate that material. Frequently, we're going to include reporting requirements in these agreements. so that whoever is the provider, they're guaranteed to get back results, any notifications of improvements and modifications. That's where intellectual property terms can often be tied into material transfer agreements. We do see MTAs coupled with service or research agreements in some instances. We also work with fee-for-service agreements, and this is when the university is providing a service to industry. Frequently, a researcher, lab, or center on campus is going to have some level of expertise, and they're going to perform some routine work with no novel input for the industry contact. When we're performing service, we do not expect there to be anything patentable or publishable resulting from the work. Typically, the deliverables are just going to be raw data, so our researcher is not going to be providing analysis, interpretation, or recommendation. And when we're performing service work, we're very careful not to compete with the private sector. And these agreements are usually entered into mainly because that service is not going to be easily obtained by the outside company somewhere else. And we do not typically allow students to perform service work because it's not going to be in furtherance of their education. The final type of agreement that we're going to talk about, sponsored research agreements. That's when an outside entity is providing financial support to the university to conduct research that is in an area of mutual interest. The intent of a sponsored research agreement is to develop new knowledge in the field, and that knowledge is commonly disseminated by publication of the results, but we do often see IP also being developed. When someone sponsors research on campus, they commonly get in exchange access to the data, the results, and options to the intellectual property that results from that project. We do want to talk about why universities and industry would want to collaborate. And one of the easiest ones to point to is cost savings. Research and development can be one of the biggest expenses that a company faces. Because it's experimental, return on investment is not guaranteed. And companies these days are frequently downsizing, and a lot of times that's happening first in the research and development area. Universities can offer ready-made labs. Industry could find a researcher whose field of research aligns with that company's interest. The company doesn't have to invest in the setup of a new lab, and there's going to be less risk when the results of the work are uncertain. And this allows industry to consider new ventures with lower costs. We also see companies coming to universities because they can leverage other sources of funding. Companies frequently are going to be combining their funding with funding on campus from the federal government, the state government, other nonprofit and industry sponsors, and at UW in particular, we have internal university grants, and we also receive funding from WARF. Some examples of how funding can be leveraged are on UW's campus. WARF has a program that provides funding to new professors to help them set up their labs. Something we also frequently see are postdocs or grad students who are going to be working on a project that is going to be industry sponsored, but that student is going to also be funded by an NIH training grant. And we consider benefits of access to really mostly be mutual. Universities typically offer state-of-the-art equipment and expertise across a variety of fields, but researchers at universities often have contacts at private companies, and those contacts and the relationships they have can form the foundation of the research relationship and really foster the exchange of ideas, resources, and information. Universities can get the opportunity to evaluate prototypes, which would provide the university pre-market access to new technology. And in exchange, the university can offer feedback and validation to the provider. Researchers on campus do reserve a right to use their background intellectual property in research without a sponsor necessarily having to purchase access to it. But having access to the university's portfolio of background intellectual property also adds value to foreground IP because it creates opportunities for modifications and improvements. And when a company sponsors research on campus, the university is really going to try to offer them a preferred licensing position, which would usually give them the first opportunity to license any IP that results. But on the university side, that also creates a ready-made licensee. And students on campus are highly trained. Their abilities are often vetted by work they've previously completed. And some sponsors see engaging students in research as a trial period for employment. A main goal of universities and a measure of their success is having students that are prepared for and are likely to succeed in the workplace. Universities and companies do have some fundamental differences which a tech transfer office or the sponsored research office needs to be able to identify and needs to remain mindful of when we're negotiating terms governing their relationships. Some of the areas that we're going to talk about just mention the distinct interests and focuses, but also legal or policy limitations that differ from the university and the business side. For example, the mission and focus are going to be very diverse between these two entities. Industry focuses on running a business, and part of running a business is staying ahead of the competition and holding a significant share of the market and making a profit. On the university side, their measure of success is usually how much they've contributed to the community, and the main goal is education, discovery, and dissemination of knowledge. And when it comes to governance, companies must answer to their owners or shareholders and have obligations to any other governing bodies, such as their board of directors. In this instance, we often see that fiduciary duties are going to inform and highly influence their business decisions. University governance structures can differ depending on their status as public or private, but typically they are nonprofit organizations who have reporting obligations to the public, but also obligations to their students, faculty, the research community, taxpayers, and again, the general public. Profiting can be a problem, especially from a tax point of view. And there are a number of other areas that we see issues arise in. One of them is conflicts of interest. Industry usually has to abide by reporting requirements. For example, pharmaceutical companies have to report payments that are made to prescribing physicians. At UW, we do have a hospital on campus, and so we frequently see these terms being included in our research agreements. We also want to make sure, and this is the same for industry and university, we want to ensure that our results are going to appear unbiased. Public universities are often subject to public record requests, which are going to prevent them from being able to keep agreement terms or research results confidential, or from agreeing to publication restrictions. A number of other circumstances can create conflicts of interest or the appearance of conflicts, but one that we commonly see that sort of overlaps between industry and academia is when a researcher has an ownership or management interest in a company. And as we mentioned before, there are some legal limitations, including other reporting requirements. Securities reporting laws will require companies to disclose information about their activities. And companies have to consider who is getting access to their private information, especially for issues like insider trading. Again, there are fiduciary obligations that are going to be owed to owners or shareholders. And there's a number of other regulatory agencies that might monitor actions for things like securities, food and drug safety, or export control. But universities also face limitations that could be imposed by their federal nonprofit status under the Internal Revenue Code. But public entities are also limited in what they can do by state laws. For example, universities often have to maintain their sovereign immunity and comply with public record requests. There are a few contract provisions that we see very often being negotiated. Confidentiality, results ownership, publication and publicity all tend to tie in very closely. When it comes to confidentiality, usually the starting point is that industry is going to want all of their information to be kept confidential as a blanket term. And that includes data and results, which is part of what gives them the competitive advantage. Usually they're going to request a perpetual obligation, so there is no point at any time in the future that the university may be able to disclose that information. Universities, on the other hand, have a tremendous amount of information coming into and leaving the university. On our campus, I think we have something like 60,000 people. And so we request a marking requirement. We believe that if it's really important to a company that their information be kept confidential, that they would be willing to mark it as confidential. But it's a mission, again, of the university to share knowledge. And so we often ask for limited term obligations so that we can see a point in time when we will be able to discuss that information, but also to minimize our use of administrative resources and to correspond with our internal record-keeping policies. And as a rule, we don't perform confidential research because we do receive state and federal funding. And our work is for the benefit of education, research, and the general public. But there are going to be some instances where we want our own information to be kept confidential. For example, if we are working on something that's not yet patented, but we want to discuss that, we would enter into an agreement so that we can exchange that information, but we don't want to have any issues with our patent filing. But also, if we're proposing future research, we don't want to be preempted. When it comes to data and result ownership, if industry is allowed to own data and results, that can limit or even end a researcher's ability to continue their line of research. That also puts limitations on our students' ability to use research results in their dissertations, theses, or even job interviews. For publication, prohibiting or putting a long delay on publication again speaks to the industry's desire for the competitive advantage. On the university side, we generally wish to make the information that we learn available to the community as soon as possible. Sometimes sponsors request editing rights, but we avoid that because we don't want to create an implication of bias, and we want to maintain our academic integrity. Sponsors typically have no say over content, but we always offer them the opportunity to allow our publications before they're released so that they can request the removal of any information that they believe is confidential or request a delay of the publication for a patent filing. Our publication terms usually go along with our refusal to do confidential research and our refusal to endorse third parties. Again, our mission is to make research and knowledge available for the public benefit. And when it comes to publicity, we sometimes see where industry wants to use the recognizable name of a university as an endorsement of a product, particularly when they want to cite some comparison data in support of product claims. But on the other hand, if a company is venturing into a new field or a new market area, they often want to keep their work with the university confidential until the company is ready to make that information publicly available. As a rule, our university is careful not to endorse third parties because we see that as a conflict of interest with our other potential research partners. And we're really careful to make sure that we're unbiased in our provision of information. For that reason, usually both sides are going to require that the use of identifiable marks always be pre-approved. Another topic that we commonly enter into discussions with industry sponsors on are warranties. Companies are familiar with industry standards and will usually request industry standards of performance. We often see them asking for the usual uniform commercial code type warranties of merchantability, fitness for a particular purpose, and non-infringement. But we're not a commercial provider, and so we cannot promise industry standards. Our research is by nature experimental, and so we don't warrant that the results are going to be fit for sale or fit for any particular use. And while we do monitor advancements around the world, we cannot guarantee that any intellectual property rights that arise under our research are not going to infringe on a third party. And for intellectual property, definitely the most highly negotiated issue that we see in our agreements. Initial expectations concerning IP tend to be the most incongruent between universities and industry. What we see is industry often wants assignment or exclusivity, royalty-free licenses, the ability to use the IP for commercial purposes, and then the ability to sublicense those rights to others. But universities must protect their interest in the IP that they develop and preserve our right to continue in the field of research. It's also very important for us to comply with our legal and other agreement requirements, and then also maintain our furtherance of the public benefit. And in recognition of that, for the remainder of the presentation, we're going to be getting a little bit more in depth into the laws and policies that inform university decisions on intellectual property and new and old licensing models. Before Kendra does get into that, I just want to give you a little statistic that we want you to keep in mind while we're talking about these IP licensing models and the policies that we're going to be relying on. 84% of university tech transfer offices are currently operating in the red.
Okay, so as Rochelle mentioned, universities have to abide by the legal limitations that may put constraints on their ability to assign or license intellectual property. The Bayh-Dole Act is a federal law enacted in 1980 that governs the disposition of IP created with federal funds. Its provisions encourage funding recipients to utilize inventions arising from research or development, maximize participation in small business firms in R&D efforts, promote collaboration between commercial concerns and nonprofit organizations, such as universities, ensuring that inventions made by nonprofit organizations and small business firms are used in a manner to promote free competition and enterprise without unduly encumbering future research and discovery, and to promote the commercialization and public availability of inventions made in the United States by U.S. industry and labor, to protect the public against non-use or an unreasonable use of inventions, and to minimize the cost of administering policies in this area. In addition to the Bayh-Dole Act, we have the 9 Points Memo. It's not a piece of legislation, but it was drafted by the institutions that you see listed here as part of a collaborative effort to address potential issues in licensing university intellectual property. Since then, a large number of organizations have signed the document, agreeing to take the 9 points into consideration when licensing with private entities. The 9 Points Memo takes societal policy and legislative considerations into account when making its recommendations, and attempts to create consistency among universities to set standards and expectations when working with private industry. Therefore, it's really intended to promote responsible licensing. Here are 3 points of particular interest from the memo. Under point 1, universities are encouraged to reserve the right to practice licensed inventions and to allow other nonprofit and governmental organizations to do so as well. Under point 2, license terms and exclusive licenses in particular should be structured in a manner that encourages technology development and use. This can be achieved in part by including milestones and reporting requirements of the licensee into the license. Point 5 really goes hand in hand with point 1 to protect the academic advancement and future research and the sharing of unique resources. Moreover, the availability of research tools is fundamental to the validation and verification studies based on published results. Bayh-Dole and the 9 Points are just 2 sources of guidance for universities. There are also a number of professional organizations which add commentary on IP licenses between industry and academia. The Association of University Technology Managers and the University Industry Demonstration Partnership are 2 of the biggest contributors. In making licensing decisions, there are several other factors which universities must consider. The University of Wisconsin is unique in that we make no claim to the intellectual property of our faculty, staff, and students, even if that IP was developed on campus or in the course of their employment, unless there is a contractual term related to funding. However, UW inventors are encouraged to take advantage of the expertise and resources offered at WARF by assigning their IP interest to WARF for patent prosecution, management, and licensing. Most universities, on the other hand, require assignment of IP created on campus or otherwise using university resources. Therefore, the policies that they have must define the circumstances where institutions even have the ability to act as a licensor of IP rights. Additionally, the sophistication and expertise a university brings to licensing negotiation is at least part dependent on the tech transfer needs and resources of that particular campus. A smaller institution, which generates a limited amount of intellectual property on an annual basis, may require outside resources and a longer time frame to finalize license terms. Finally, institutions may wish to take into consideration the various reasons for entering into a license agreement. Some institutions generate a significant amount of revenue from which they can use to fund further research. For others, the purpose may be solely to maintain an ongoing relationship with the research sponsor or to further the goals of the Bayh-Dole Act, the 9 Points Memo, and their own mission by ensuring that beneficial IP is developed and made available to the public. So obviously, successful relationships with our industry partners are essential in meeting these goals. The model that most universities use is something like this. License discussions often begin at the research agreement stage, when the terms and conditions governing the project are negotiated. At the UW, our sponsored research agreements often include a requirement that all IP created from the research be assigned to WARF. And at a minimum, we'll often see, not only at the UW, but across the board with universities, that the research agreement includes a non-exclusive royalty-free license for internal research purposes. When IP arises, the university inventor will disclose to the institutional tech transfer office, and then many universities will conduct an equity review to determine the sources of funding and contractual agreements which may impact inventorship and ownership. Finally, once IP has been evaluated and the sponsor may be interested in negotiating a license, then we'll enter into those negotiations. And this may be long after the research project has actually been completed. In every case, we're going to see this go by a specific case-by-case analysis. Because you're going to have different sources of funding for every lab, there may be background IP of that own particular lab or the university in general, which may be necessary, or of the sponsor. And there may be other agreements which impact the disposition of that IP. Before going any further, I just wanted to make sure we're all on the same page when discussing licensing terms. Some of the terms that you may commonly hear are NERF, which is a non-exclusive royalty-free license, which is usually offered to sponsors in exchange for funding. This is at the research agreement stage. Usually, these NERFs are not sublicensable, and they're typically limited to internal research purposes only, rather than making it available for commercial use. Foreground and background IP is used to designate how and when relevant IP is created. Foreground IP is prospective at the time of the agreement and is expected to arise out of the funded research. Background IP is developed either prior to or outside of the current project, but may be required to practice the foreground IP. Fully paid up is a term referring to licenses, often used interchangeably with royalty-free, though it could indicate that a one-time fee has already been paid for that license. Finally, blocking IP comes into play when the sponsor and researcher have closely related projects or using each other's proprietary materials, and improvements or modifications of one may limit the uses of the other if those are patented. Universities are putting increased focus on easing the IP license negotiation process. New approaches focus on ways to reduce negotiation time, minimize company risk and cost, add certainty to the agreements, decrease administrative costs, increase researcher involvement, and to reduce the number of contracts required. To give an idea, of how specific schools are seeking to make license negotiation process easier and more straightforward, we're going to briefly describe the unique systems at 3 universities. We don't by any means consider ourselves experts on the details of each model, but they do present interesting departures from the standard practice, and they may prove to be insightful test cases. So first we have the University of Arizona's Arizona Choice. This gives licensees 4 options to choose from prior to the start of research, so at the point when the research project is being created and those agreements are first being put into place. Option 1 is a NERF. There are no additional fees, but no sublicense rights. Sponsors are offered an option for an exclusive license, but that would come with an additional fee and under a separate agreement. For sponsors who are interested in an exclusive license, there are 2 options. One has an upfront payment of 20% of the total research cost, but that has low royalties which only apply if net sales exceed a $25 million threshold. There's also an exclusive license option that's royalty bearing. It comes with only a 10% upfront premium of the research cost, but a 1.5% royalty rate does apply. Finally, in rare instances, the university is willing to consider assigning IP rights to research sponsors for a fixed fee payment of 10% of the research cost. However, this is only available when there's an expectation that the only IP which might arise would potentially block the sponsor's background IP and impair freedom to operate. Next, we have the University of Minnesota, right here in town, the Minnesota Method. For new IP generated under a funded research agreement, sponsors have two options. Option A is an exclusive license with sub-licensing rights. That comes with a fee of 10% of the research or $15,000, whichever is greater. That comes with 1% royalties on sales over $20 million a year, with no cap unless the invention is an improvement to pre-existing process and to the sponsor's pre-existing process or product, and then that's capped at $5 million. For this option, background IP is not included, and the sponsor is responsible for managing patent prosecution and paying all costs and fees. However, the sponsor does get to own the data from the research project. Under option B, the sponsor and U of M will negotiate a license after the IP arises. Therefore, there are no upfront fees, no predetermined royalties, and once the agreement is reached, once a licensing agreement is reached, the sponsor manages prosecution and pays all associated costs, but collaborates with the University of Minnesota on patent claims. For sponsors who are interested in U of M's existing IP, they have a try and buy program. This starts with a trial period for any potential licensable IP, which has a single fee and a short term of use. If at that point the sponsor is interested in continuing use, there are published royalty rates for that particular IP, with the option to buy out of paying royalties prior to gaining initial access. Finally, we have Penn State. And under their system, it's a general approach, there's no options, it's sort of a single thing. Sponsors may request ownership if they are the sole source of funding for that particular project, which the IP is expected to arise from. In this situation, all of the involved researchers must agree to assign their rights, and the background IP must be identified and disclosed before research begins. The university also reserves non-commercial research and educational use rights to any IP developed on campus. And there's also what's called a bonanza clause, which means that if the IP results in an exceptionally successful financial benefit to the sponsor will agree to share profits with Penn State and with the inventors. So as I mentioned, these are relatively new and untested systems, but if you're interested in learning more, we encourage you to check out the websites shown here.
So these new IP licensing models are new, but also therefore untested. And so there's a number of questions and considerations that are floating around. There's a few possible scenarios that we want to consider, but before I do that, I want to remind you of the goals of these new models. A few of them include reducing negotiation time, minimizing risk and cost, adding certainty, and increasing researcher involvement. So what if no intellectual property is created? A few of these models include upfront premium payments to guarantee access to intellectual property, but you could be paying when there's no guarantee that there is even going to be a resulting technology. This is where we see increased researcher involvement being very important. Companies are going to rely on that researcher's knowledge of the scope of work that they're going to be undertaking, what the resulting IP may be, and what the value of that resulting IP could be. Researchers may also be upfront about it and say that they don't think intellectual property will be created. Another question is, what if the sponsor is uninterested in IP that they've exclusively licensed in advance of the project? As we mentioned when talking about the Bayh-Dole Act, the goal of that act is to encourage the sharing of knowledge and the development of technology. If technology is exclusively licensed to a sponsor who is uninterested in it, that's highly unlikely to get to the market. Another issue is if that IP's value is lower or higher than anticipated, and that doesn't correspond with the royalty rates that are agreed to. Predetermined royalty rates could be higher or lower, which would be to the detriment or the advantage of one party and not the other. Another issue is if background IP is already exclusively licensed. As we've seen, you could be performing consecutive research products with different research sponsors, and the background IP could have been exclusively licensed in the first phase, and the foreground IP in the second phase could rely on that background IP. In that instance, and this speaks to the goal of reducing contracts, the foreground IP sponsor would have to go to the background IP sponsor outside of the university and negotiate with that industry organization to get access to the background IP. And finally, one concern is the restricted use of IP-related data or know-how in future sponsored research. We have seen some of these models do require a reservation of rights to the researcher or the university in general, and that may prevent any issues arising from here. But universities typically, as we mentioned, want to own the resulting data. And if an industry decides to take ownership of that, we're not certain how that's going to affect that researcher's ability to continue their line of research. But as I said, these are questions and considerations. We don't have answers. But we do applaud our colleagues for taking some serious steps. And we thank them for being the front runners of this effort. For more information about UW's policies, our office in particular, we invite you to visit our website. We're also happy to answer questions, so please don't hesitate to contact Kendra or myself by phone or by email. And we thank you for your attention.
All right, we're going to take a quick break now, about 15 minutes, so we'll be back.